Talk Show. Recorded live.
Welcome, everyone, to tonight's Wednesday night call, The Free Americans. It's our regularly scheduled 8 p.m. Eastern Time call. Before we get started tonight, I'm going to read our disclaimer. This show is private and not to be construed or relied upon as being legal advice for an individual legal situation or employed for making legal decisions. You will not use any of this information for making a legal decision or performing a legal procedure and is not a substitute for legal advice and or guidance by a licensed attorney. This private show is for academic, informational purposes only, to be used at your own risk without liability to Christian Walters. By accessing or reviewing the show, you understand with agreement that with all rights reserved without prejudice, Christian Walters is not an attorney licensed to practice law in the state of Florida or any other state and has not given legal advice or accepted fees for legal advice, provided no assistance, advising, or guidance of any kind for use by non-attorneys or pro se parties in the preparation or use of the herein reference, and has no interest in any issued reference therein, and is not a party to this or any action arises from, and is only acting in an authorized capacity as liaison to communications between the parties. Listening to the call tonight, you acknowledge and agree that you are not a client of Christian Walters. The show recordings are incomplete and void without this notice agreement being attached herein by reference, and a breach of this agreement. Upon breach of this agreement, the breaching party becomes liable for admiralty commercial damages of $100 million or more per stultification or impairment per Christian Walters' discretion. And with that said, I'm going to unmute Christian here. If I can find him on my list. There you are. Can you hear me, Christian?
Man, how you doing tonight?
I'm doing great. Are we going to be in Gilbert Law Summaries again?
Yeah, I think I want to just maybe touch real briefly on trust purposes on page 64.
Page 64. All right. Folks, if you got your Gilbert Summaries book, we're on page 64. This is 13th edition, 2008, Gilbert Law Summaries on Trust. Starting on page 64. It's all yours, Christian.
Okay, welcome everybody. I'm your host, Christian Walters, so we'll be going over this section E under trust purposes here on page 64 for a little bit, and we may jump to something else, but might open up for some questions kind of early though. And so I want to touch on these trust purposes again. I think we've gone here once before. So number one is section 223, where the requirement of lawful and an appropriate purpose, where a trust may not be created for a purpose that is illegal or contrary to public policy. Statutes in some states provide that a trust may be created for any purposes for which a contract would be made. And you might want to substitute the word contract in there for a trust. But it is not at all clear that these statutes alter the purposes allowed or prohibited by the general common law of trusts. And under A, the private trust, section 224, usually the objective of the settlor is to promote or secure the welfare of some person or limited number of people. Examples would be spouse, children, family, etc. And this is, of course, a permissible private trust purpose. In fact, it is increasingly accepted that a private trust, its terms and its administration must be for the benefit of its beneficiaries. B, charitable trust, section 225, where the settlor's objective is to promote the welfare of members of a large and indefinite group of individuals, example, students at a particular school through a scholarship fund, or of the public at large. The trust purpose may be considered sufficiently important such that the special rules apply to trust as one having a charitable purpose. Next, section C, honorary and mixed trust, section 226. Except for the special case of purpose trust or honorary trust, and see supra, section 170, a trust must either be private or charitable, or if the interests are separable, it may be partly each. And however, a transfer that does not create a private trust generally cannot establish a trust for purposes that do not qualify as charitable. And it gives a case there, NCC, the restatements of the third, section 47, where it's encouraging a somewhat liberalized set of rules and concepts for purpose or honorary trusts. Number 2, impermissible trust purposes, sections 227. So occasionally a trust, or more often some provisions therein, may be challenged as invalid if it appears that the settlor, and I put in there or other parties, was attempting to accomplish an objective that is illegal and requires the commission of a criminal or a tortuous act by the trustee. I put in there also trustee or other party, or would otherwise be contrary to public policy. Next section, A, fraud on creditors, 228. And this could also be applied to fraud against the settlor/beneficiary. So an example of an invalid trust purposes is where the owner of property transfers it to another in trust for the transferor for the purpose of concealing the property to hinder or defraud the transferor's creditors. And I think that's really how they're construing a modern view of, say, the Declaration of Independence. Because they're saying that you're trying to get out of wiggling out of paying your debts, and you're defrauding your creditors. So to settle the creditor's attitude so that they would say, okay, we do have some kind of a right to come after the beneficiary's assets, because if we claim the Declaration of Independence, say, being unalienable rights can't transfer it, then it's like, oh, all right, then you got the right to do anything that you want and defraud us in any way and expect to get away with it. So I think that's their rationale that they talk about under that section on the protective trust. So continuing on, 1, the effect. In this situation, the trust is regarded as a nullity, and the creditors of the settlor may reach the property as if the trust did not exist or set aside the transfer as fraudulent. Compare under a somewhat similar but different principle, a transfer in trust, like an outright transfer, may be a fraudulent conveyance, even though it is not otherwise a nullity or illusory. That is, even though it is generally for the benefit of others, an example, the settler's family, if the transfer is not for adequate consideration, and if the transferor is, or is thereby rendered, insolvent, or if the transfer was made with intent to hinder or defraud the transferor's creditors. And 2, can settlor regain property? Section 229. So suppose no creditors materialized, or that the transferor was able to or forced to pay his creditors out of the other funds, will he be permitted to compel the transferee to return the property? And A, in some cases, hold that he cannot, and his purpose may be considered to be so improper that he is not entitled to relief in equity. In other words, he has the unclean hands, as equity will not leave wrongdoers where it finds them, or will leave wrongdoers where it finds them, And the express trust will not be enforced, and no constructive or resulting trust imposed. Under such a rule, even a dishonest transferee may be allowed to retain the property. And B, other cases hold that the determinative factor is whether the intended fraud actually succeeded or involved serious moral turpitude. If no one has been hurt, and especially if the offense to policy is not serious, a court may order the return of the property to the transferor to prevent unjust enrichment of the transferee. So there's the causes of actions, and we've gone through that. So for a counterclaim, say for a breach of trust, you've got these impermissible purposes, and the causes of action would be a transfer, fraudulent transfer, and then you could come in with the unfair business practice, and under tenancy or purchase or products and services, and under the next one would be insurance claims, and then the last one would be debt collection, and that would be all falling under unfair business practice. And then you have the unclean hands doctrine as a cause of action, and you also have the unjust enrichment as a cause of action. And the big one, the one I saved for last, is really the antitrust for a cause of action. And you might want to see page 94, which gives reference to the CCI, the Confidential Commercial Information / Trust. Page 94, under C, Section 336, which is abuse of confidential relationship, where the constructed trusts are frequently imposed where the transferor, the grantor, and the transferee, or the trustee, stand in a confidential relationship, that's a trust, to each other, and an intended trust conveyance is made in reliance thereon. And in such a case, the transferee's refusal to carry out an oral agreement to hold in trust is a breach of confidential relationship. And thus, the same result would apply as when the transferee obtained the conveyance through the closely related conduct of fraud, duress, or undue influence. A constructed trust is imposed. And then dropping down to number 1 there on page 95, what constitutes a confidential relationship? And it also lists in that section, it says trustee / beneficiary. And then the next section where other confidential relationships, and it says under 338 there that the scope of confidential relationship, there's your CCI, is rather broad. The confidential relationship may be shown by proof, actual habitual reliance or dependency by one person on another. So it says down a little farther, in such instances, courts do not require much more to show an actual relationship of confidence. So back to page...
Hey, Christian, you mentioned that you need to have a protective order put in. Could you tell us, you had mentioned a book that we needed to obtain. Was it Federal Rules of Civil Procedure with comments? But there was a specific one that gave all the points of that protective order that needed to be, I hope I'm not jumping ahead of myself here, but I remember you mentioning that.
Yeah, that was O'Connor's Federal Rules, Civil Trials.
Federal Rules?
Yes, O'Connor's Federal Rules, Civil Trials.
Federal Civil Trials, okay, thank you.
In fact, also Federal Civil Rules Handbook also. That goes into it also. That's Thompson West publication. That O'Connor's was a, who publishes that? Jones McClure.
Jones McClure
is the publisher on that one.
That was Federal Civil Rules?
No, that's O'Connor's.
Oh, that's right.
Yeah, Federal Civil Rules is Thompson West.
Thompson West.
Thompson West. Thomas West, excuse me.
Thomas, okay. Thomas West. Thank you.
And what I was also thinking about your evidence we talked a little about was this Florida and federal evidence rules. Now they make that for Florida, and they make it for New York, they make it for Texas.
Wasn't it 90, or was it 90-5 and 90-6 for Florida evidence rules?
Yeah, 90.501 through 510.
Talks in there about if you bring it up in open court, you voluntarily waive it.
Yes, that specifically is 90.506, privilege with respect to trade secrets, and 90.507, which is waiver of privilege by voluntary disclosure. And there was a fellow on the call last night that he actually, in fact, I commended him on it because he went to the law library and he did some research on protective orders. And he found in Bender's the forms that he needed, which made specific reference to his state laws, and he said he filled out the form the way it was and put it in a court, and the court knew exactly what to do with it, and they didn't complain, and he ended up getting his protective order.
Wow. What state was that?
I think that was Massachusetts.
Okay.
But all you got to do is go to your local law library, do some research on protective orders, And every state, I believe, has Bender's in it. And Bender's is making it for your local rules. And just look in the Bender's book, and it's going to probably give you the standard form that comports to your local court. Otherwise, you could get the O'Connor's here, the examples. It gives protective orders examples in there, and the book explains all the elements necessary for a protective order. And all the states really model after the federal anyway.
Right.
So it's going to be pretty much standard. All right, page 66, the top there, number 3, where it talks about distinguish protection of beneficiary's interest, section 230. So while the settlor cannot employ the trust device to avoid his own creditors, he can employ it to shelter the interest from the beneficiary's creditors. And see 460 through 489, which is talking about the spendthrift trust, discretionary trust, and a protective trust. Yeah, so that's, I don't know how far we want to get into the trust purposes here. Kind of wanted to touch upon that right through that section there. Now this kind of points out to the fact here on page 65 when it's talking about these causes of action there. And I was trying to point out the other night on some of the other shows in that really that the real power is, what we're not really realizing is in the prevention of breaching the trust. There's more power there than trying to enforce the breach after it's been committed. And I don't think we're seeing it as being a power because we're thinking, okay, you know, I'll enforce it after the breach. No, you can enforce it before the breach. Because if it looks like somebody's going to breach the trust, you come into court of equity anyway and say that, hey, equity will compel you not to breach the trust. Now that is really powerful. You stop to think about it. There's your big stick for getting these people in line, these banks, these other big agencies and things, because they're really the servants of government, but since the tail is now wagging the dog, these agencies are telling you what to do. Only because you don't know and understand there's a trust here, although they do. So to prevent somebody from breaching the trust and having to come in with a cause of action, that has the bigger power, I believe. So let's give an example to that. Let's say, okay, you go into a bank and you want to open up a checking account and you want to put it under trust, and when you sign the signature card, you're going to sign by grantor, and they say, no, you can't sign that way. Oh, yeah, why can't I? Why can't I sign that way? Because it's against some kind of public policy, or not public policy, company policy? So what they're trying to do is construe it under debtor creditor, because all they want is your signature so that you can give them the signature unrestricted so they can do anything they want with that signature and fractionalize and turn it into debt currency, which functions as money. So what do you do in that case? Well, I was trying to prevent the breach of this trust because you guys really have a duty to be servants of the trust, the grantors, and to prevent you from breaching that, you could come in with some causes of action and actually compel them not to breach the trust. Because don't they have a monopoly with their hordes of attorneys and their legal departments with scores of knowledgeable people under unconscionable laws based on liar's contracts? And they're trying to dupe you into submitting to that? So Article 4 in UCC, Article 4 is bank deposits and collections. So there you are, the bank trying to open up a bank account so you can make a bank deposit. And what would a bank deposit be? Well, it would be a special deposit if you could tell them that's what you're doing, but since they won't allow you to really make a special deposit, say, or maybe they won't allow you to sign the contract, the application there, the signature card by grantor. Well, 4-103 states that variation by agreement. 4-103, that's variation by agreement. So it's measures of damages, and it's also actions constituting ordinary care. Ordinary care. And it's quite short, really. It only has an A through E section, but then the real thing is the official comments. Where under the first official comment says that Section 1-102 states the general principles and rules for variation of the effect this act by agreement and the limitations to this power. And Section 4-103 states the specific rules for variation of Article 4 by agreement. Skip it down farther towards the end of that number one comment, it says it would be unwise to freeze present methods of operation by mandatory statutory rules. Very interesting. So this section, therefore, permits within wide limits variations of the effect of provisions of the article by agreement. Section 2 says Section A confers blanket powers to vary all provisions of the article by agreement of the ordinary kind. The agreement may not disclaim a bank's responsibility for its own lack of good faith. Lack of good faith. Or failure to exercise ordinary care. It may not limit the measures of damages for lack or failure. But this section, like 1-102, subparent 3, approves the practices of parties determining by agreement the standards by which the responsibility is to be measured. So in the absence of showing that the standards manifestly are unreasonable, so when you walk in there, aren't they being unreasonable because they won't let you sign the way you want to sign to express a trust? And isn't that a lack of good faith or a failure to exercise ordinary care? And doesn't that constitute monopoly? Don't they have an unfair advantage? Because number one, they're holding it over top of you that, hey, you can't get an account here unless you sign it the way we want you to under debtor-creditor. Maybe I don't want to sign under debtor-creditor. Because that's going to stop you from making the fiat currency and gaining all access, unqualified signature, or access to my unqualified signature. I'm giving you carte blanche. But now I know what's going on. And I want to give you carte blanche. But I can come in with breach of trust or preventing a breach of trust on a court of equity and compel you, Mr. Bank, to give me an account, or else it's going to be monopoly. You're trying to get me to sign an unconscionable contract. You can go in and look up unconscionable contracts under UCC. But the place you really want to look is in the Bank Officer's Handbook of Commercial Banking Law. I keep going to that section 19 there. Section 19.02. And it reads like a bunch of dominoes. It starts up talking about special deposit under Section C or Section 2C, special deposit, and 2D is this certificates of deposit. And then we'll skip the now accounts in E, and the F, automatic transfer accounts, we'll skip that, and G, the shared draft accounts, and the money market accounts under H, but then in the next section 3 says opening the account. And the opening account really says that really it's all by simple contract. There's that contract again, that agreement. An opening an account in a bank involves only a simple contract in which the depositor lends money to the bank in return for an agreement by the bank to pay back the amount either with or without interest. And jumping down a little farther into that in the next paragraph, it says that these contracts or these agreements are usually drawn so to give the bank the maximum protection in the circumstances. But if they are unduly harsh and one-sided, or if they unfairly surprise the customers, or attempt to disclaim responsibility for acting in good faith and with reasonable care, ordinary care they changed that to, they may not be enforceable against the customer. I'll read that again. They may not be enforceable against the customer. The federal law requires banks to give special notice of some bank policies. And it says that the notice on bank deposits and ATM sites and signs in the bank and certain bank policies. But skipping down to the next section then, section 4, unconscionable agreements. This is antitrust really, folks. Unconscionable agreements. Standard printed contracts which the depositor is asked to sign and which are made out in advance by the bank lawyers are common not only in commercial banking but throughout the business world. A well-known rule of law incorporated in the UCC is that between the parties, rules of law can be changed by agreement. Let me read that again. A well-known rule of law incorporated in the UCC, and that's making reference to 4-103, UCC is that between the parties, rules of law can be changed by agreement. Thus, courts in the past have enforced contracts signed by the parties that worked a hardship on one of the signers. Taking advantage of this rule, banks and other business sometimes have created standard form contracts that give them great advantages and require their customers to waive legal rights, but only if you don't know. So courts will provide relief to customers from such contracts when they find them unduly oppressive or unconscionable, when such contracts are not negotiated by the parties with equal bargaining power and understanding. Let me ask you, do you have equal bargaining powers and understanding with the bank? If you don't, or if they do, then there's a monopoly. And when they work a hardship on one of the parties, they may be found contracts of adhesion or unconscionable contracts. And under the UCC, courts refuse to enforce these contracts against the injured parties. Sometimes banks form contracts providing that the customer shall not hold the bank liable for losses caused by negligence or wrongdoing on the part of the bank or its employees. Agreements of this sort are made illegal and void by the express provisions of the UCC and are therefore unconscionable. Such stipulations do little more than create ill will on the part of the customer and invite charges that the bank has acted in bad faith. Further, a bank contract with its customers will be interpreted in light of the course of dealings between the bank and the customers. As a result, action by a bank that is inconsistent with an established manner of dealing between the bank and its customer may not be proper, even though the written contract is ambiguous or lacks a specific clause on the matter. The UCC also specifically provides that the contracts between the bank and the depositors shall be performed in good faith. The bank's duty of good faith to its customers is discussed in Chapter 24 of this book. So that's out of the Bank Officer's Handbook of Commercial Banking, 6th edition, section 19.02. tying that in with UCC 4-103 under the official comments and other sections that apply unconscionable contracts in UCC also. But what I'm trying to point out is that you really have the greater power instead of cowing down to these people to sign these unconscionable contracts. Know and understand that they are unconscionable contracts, and you don't have to cow down to them. And if more of us would take these people to task, we'd get our government back because we'd be acting like the government. Sometimes you got to take a wayward child, take him to the woodshed, and give him a little tanning now and then. If more of us did that with these stupid agencies, maybe the head of the dog would wag the tail instead of the tail wagging the dog. So let's wake up, people. So, anybody have any comments or?
If you got a question for Gretchen, folks, go ahead and hit *8 on your phone. And I'll be happy to unmute you so you can ask your questions. *8, folks. First caller, Ingris.
Yeah, hi. This is John from New Hampshire.
Hey, John.
How's everybody tonight?
Good.
Good to hear you. I was wondering, I have a slew of questions, so everybody else can hang up now. Only kidding. But could you describe proper filing of the UCC-1 where you're claiming the notice of interest?
Okay, I was going over that and reviewing that today, and I'm really coming, people are having a hard time grasping this UCC filing, and I think there's a couple of reasons why. And for one thing, there's all these ingrained habits of how we've been using UCC filing in the past. And I think also it's the fact that they're not really realizing since the year 2000, UCC has really been changed. 2000 brought a year of change in the UCC where prior to 2000, the UCC was just used to, it was actually used to perfect a lien, but no longer is. That's the big change since 2000. 2000 brought on the fact that it was just a notice filing. UCC is nothing more than a notice filing. The notice filing is saying that, hey, we're notifying you that you need to do your due diligence and go back into the records and do some further searching because there quite possibly might be a lien here, but you need to check it out for yourself. That's all that boils down to. That's a notice filing. So what I think I've discovered is that really it comes down to this, why a lot of people are having confusion on this UCC. It comes down to the notice filing. It's the trustee is identified only when he shows up with the offer for the debtor-creditor relationship, and then you express it as a trust. Now, that could happen prior, say, 3 or 5 or whoever knows however many years in the past. Because it's when the actual transfer of trust res property occurs, and that's always going to be past tense when you're doing the notice filing, because the notice filing does not establish the formation of the trust. It's the actual transfer of the property to the trustee. Whenever that occurred, that's when the trust was formed. And that could be 6 months back, 6 years past. But anyway, it's in the past. And I'm going to do a present notice, say, filing of the existence of the trust, which I'm going to use to prove the records, prove the trust with the records. So that is, I think, the major problem right there. And two, the UCC notice and the notice in the courts is not the mechanism that forms the trust. It's the present transfer of the trust res. And the present transfer could have happened, say, 6 years prior. And now you're coming around now and filing the notice to create the records for the trust to prove the trust. That's what I think, those 2 points is where the major confusion lies on the use of the UCC.
Okay. As far as creating a title, can you write your own deed for property?
Yeah.
And then,
you know what a deed is?
A deed is an action, right? A record of an action?
Yeah, it's just a recording and by words of what you did, a recording, writing down your actions. And that's a deed.
So in regard to a title, where the warranty deed is listed as basically as legal title in Black's Law, I believe is how it would be interpreted, right?
Any act of a human or a real live man or woman is a deed.
Okay, so you can write your own deed, but what's to prevent somebody from doing this to you on your property, putting a notice that's just a registered mail number into the public, and when
was the trust formed? Who's going to have priority?
Okay, but how are you going to find out? Do they have?
You know, I don't have to find out anything. All I got to do is make an accusation. It's up to you to say prove the trust.
Uh-huh.
You can't prove the trust, then there is no trust.
Okay, I want to jump around a little bit. Is the statement of interest pretty much identical to a notice of interest?
Absolutely not. Notice of interest is, hey, you just broke my arm. Where's the proof of that? Well, I got x-rays, I got a sworn affidavit. That's the material facts. That's the SOIs.
Okay.
If you don't have the SOIs, the NOI times out.
Okay.
Unsubstantiated claim.
Okay. And if you were in the process of getting together a bunch of documents that you are going to put on NOIs, and you said they all have to be listed individually, one per notice of interest, correct?
I'm not quite getting your question there.
Okay, we talked Saturday. You said that there are 3 trusts in a mortgage situation.
Right.
And I believe you've been saying that you have to put each one of them separately on a separate NOI. Is that correct?
Well, I would treat the one in the county as a separate trust, and I would combine the one from the bank that was at the closing at escrow into the case that they were, say, coming at me in a foreclosure. I would combine those 2.
Okay. How's that again?
Encompass the bank's original, you know, where we closed everything in a trust and escrow at the mortgage closing.
Okay, so I'm sorry, I missed that, and I don't have it on, I'm not recording it, unfortunately.
County one I'm going to treat solely separate, as a separate issue.
Uh-huh.
But the 2, the case that they're foreclosing against me on, and the original closing of the mortgage, those 2 I'm going to combine. Because the case is going to encompass the original trust formed at the mortgage closing. Okay.
When you say original, are you saying that if you've had refinancings in the past, you still have to go back to the first?
Well, if you refinance, you got another trust.
Oh, really?
Christian, doesn't that original trust close down if you refinance because you pay off the...
That one closed out, yeah.
Yeah, so
The
it's
refinance,
just the most recent, right?
Refinance created another new trust.
Right. So you got to go back to that 1003 mortgage application that you signed.
Yeah,
For the refinance.
I'm having trouble, recognizing where's the trust at. There are many trusts, but it really comes down to identifying what I keep coming back down to is the signature. But the signature put on what? Well, on the original offer that's coming at you at the time. Because it's the same way what we're using under debtor creditor, which was when somebody gives you an offer, that's what you're going to do the accept for value and return for value on. Well, that's the same thing under trust also. You're going to look for the original offer. The offer is the one you want to turn into the trust. And that's where the trustee is ID'd only when he shows up with the offer for the debtor-creditor relationship when you didn't express it as a trust. So it's the offer, or the same thing you would do the accept for value on. That's what you want to form the trust on, to help those people identifying where I'm going to form the trust from. It's the offer. The bank foreclosure action. That's an offer for a debtor-creditor relationship or a trust relationship, whichever way you want to express it, or don't express it.
Well, I hope you're going to be having your workshop soon. This is a lot of information to...
I think the major part of it is we're so wrapped up in brainwashing so far under debtor-creditor that's what's really hampering us to really seeing the simplicity of the trust.
I think you're right, Christian. I think that's a good point.
I wanted to jump over to another question. You've talked about the AFV being a debtor strategy and the same thing with the birth certificate bond. Can you elaborate on why you say that?
Well, you see, the whole system is designed to function on debt, which is functioning as money, which is really credit. And so what they're doing is they're duping you to volunteer your signature on some debtor-creditor instruments so they can create more debt, so they can create more money, unbeknownst to you. That's debtor-creditor relationship. But you see, we don't need to function under debtor-creditor. Don't have to function under that. You can function under trust. What's going to happen is that you're going to dry up their ability to create debt, which they're going to use as functioning as money. And they don't like that. So they get sole source use of it, and you don't. But here it was a trust altogether, but you never expressed it as a trust, so they're going to construe it under debtor-creditor. And all they're doing is creating more debt so they can use it as money. And you never see a dollar of it. You get a benefit that they're administering to you. And it should be the other way around. But if you knew who you were and you understood that, then you could come in and express the trust, and you're setting yourself up as grantor, and then you got the ability to set the terms, whether it be your trustee or whether you're going to be beneficiary or who's going to be trustee or whatever. You're the one making the rules.
Okay, well, I'm sure I'll be back to you again with more questions. Thank you very much.
Well, let me ask you this. Was that anything, did it clarify anything?
Well, to be honest with you, I've been having trouble figuring out how to record while I'm using my Skype, so I'm half my attention is right now on muting the phone properly, using the speakerphone, recording with one of these little doodads over here, and trying to take notes on what you're saying. So it's
this call is being recorded. Did you know that?
Yeah. No, you mentioned it.
Yeah, every Wednesday night our calls are recorded and they're available on a TalkShoe.
Great. That's what I needed to hear.
So what you should do is go out to the Yahoo groups, The Free Americans, and become a member. And then every Wednesday at about 2 to 4 p.m. in the afternoon, you'll get an email reminder for the email that you put into that Yahoo group account,
Uh-huh.
and there's a link on there for a TalkShoe, and you can click on that link, and it'll take you right out to the website. You can't find it by just punching in the TalkShoe ID 41875. It's a private group, so it won't show up. You have to have the link.
Okay, great. I appreciate that.
Absolutely.
Thank you.
All right.
Bye-bye.
Got another caller here. It's a non-member. What's your name and where are you calling from, please?
Hey, Matt. Hey, Christian. This is Eric.
Hey, Eric.
Yeah.
Hey, I was on the Florida Administrative Weekly and the Florida Administrative Code website. It's flrules.org, and I was trying to figure out how to cross-reference the UCC to the administrative rules because I was looking in the rules on the other. Let's see, I'm not looking at it right now, but in another Florida state website, and it jumps from Chapter 66 to 68. So then I put in Florida rules in Google, Chapter 67, and this is the website I was able to find. But what I'm trying to do is figure out how to cross-reference the UCC to the Florida rules so we can use them in our documents, and maybe by doing this, we'll teach other people how to do it in other states. And I can shoot Matt the link that I'm on, and maybe you can even look at it, and we can figure out how to do this together and walk through it. Would you do that with us?
How to link the Florida rules, how to get UCC to comport to that, you mean?
Yeah, exactly, because you said put a 67 in front of it, right?
Yeah, Florida statutes. 670, say, let's say I have like 9-210 under UCC.
Right.
So if I just put a 67 in front of that, so I get 679, and then I want to take the dash and put a point instead of a dash. So it's 679.210. And that's Florida statutes.
All right. So that UCC rule is going to become a Florida statute, actually.
It's all codified under Florida statutes, yeah, verbatim.
All right. Let me Google that and just see what happens.
And then usually at the end they may put like a 1 on the end. They change it around a little bit, but really that'll get you in the right area so where you can double check them because sometimes there may be some additions on the end there a little bit. But if you just generally put 67 in front of the UCC number and take out the dash and put a point.
All right, I'm looking at 679 right now to see if I can find the .210 one. And just see, there it is right there. Oh, no, hang on.
Of account.
Let's see, I think it's under Part 2. Let's see if we can find this. 20, it starts with 679.2011. 679.210, and that's request for accounting, request regarding list of collateral or statement of account.
Go.
And I will check that against AUCC 9-210 and look at it.
9.210, whatever the number is, and you can put that right in your pleading then.
Right.
You got the statute.
So we can cite the statute. Okay. And perfect. Now, do you know if it's that way in other states by any chance?
Well, it has to be. Yeah. I don't know how their nomenclature goes according to their statutes, but some way it's going to be somehow, to where the UCC is in their statute or in their state statute somewhere. Has to be. So it's incorporated in all 50 states somewhere.
Now, I'm looking at 679.210, which is also the same as UCC 9-210. Now, let's say I'm right into my bank because I'm trying to get them to provide me a statement of accounting, which we know they're not going to do, but either way, when I make the presentment, then we can get them in the position of unclean hands by their non-response. Now, do I want to use the Florida rule, or do I want to use the UCC, or do I just want to cite the language in it?
Well, it depends where the bank is and where your case is, really.
Well, if there's not a case yet, if I'm using this if it's going to wind up, for example, in the county court, so I wouldn't want to use Florida rules because they're going to be able to recognize it. Is that what you're getting at?
Yeah, if I have the local bank I'm doing business with, yeah, unless their main office is in, say, New Jersey and I'm in Florida here or something.
Well, it's Chase, and I think their main office, I don't know if it's in Chicago or New York, or I heard that it was right here in Maitland, so I'm just not sure.
But my point is, I'm really not going to put, say, 9-210 in the request for validation of the debt or the statement of accounting. I'm just going to use the principle or the intent of that UCC, and I'm going to make all the provisions that UCC has in there. I'm going to mark it for the 14 days, and then they've got 14 days to return. And then I'm going to put in there that the value of the account is, the statement is 0. And then when 14 days, if they don't respond, now got me a certified dishonor from the notary because he's going to do the presentment on that. Now, if they come at me any way, I can put the actual statute, whether it be UCC, say, for federal, or if they come at me under the state, I could bring in the state, comport it to the state rule also, either way.
And, of course, this would be a strategy to go in the public side of the court for a cause of action that we could control to the private side, as you've mentioned in the past, right?
Yeah, that 9-210, I'm using that for two reasons. That's going to set up a statement of account request, and I'm going to set up the value to be 0, that I don't owe anything. If they don't respond on that, then they're in agreement that the account value is 0, that I don't owe anything. That's number one. Also, when they don't respond back, the certificate is going to, the notary certificate is going to generate a dishonor, and that dishonor is going to fall under the unclean hands doctrine. Which, if they're going to take me to court with that certificate, the unclean hands doctrine, I'm going to get that case thrown right out of court because equity says they can't come into court and ask a court of equity to foreclose on me when they themselves are not doing equity. And that since they've got unclean hands, they're not doing equity. I will get a permanent injunction against that company from ever coming at me again.
And under number 1 that you just mentioned a moment ago, would that be by tacit agreement?
Yeah.
Okay.
Agreement because they didn't respond under the notary request to validate the debt.
But if we were to
prima facie evidence that they have unclean hands.
And if we were to go to court to argue it, this of course would be on the creditor-debtor side, it would be that we would argue that they agreed to it by tacit agreement. That's exactly the premise.
Okay, but now we go into equity side of the court. Because
right.
We want to invoke equity.
Of course.
Here's where the protective rule and the substantive rights of the man need to be protected in order to bring in the certificate in chambers again.
Okay.
And once we're in chambers and I produce that certificate and prove that there was unclean hands certified by the notary, which is outside the hearsay rule because it's self-authenticating, that notary certificate. That's the proof that they have unclean hands, and now we got a problem here, Mr. Court. You know, they got to be barred and thrown out.
And, of course, to make that argument, our pleading would have to be with all the proper elements that we could get out of O'Connor's, as you had talked about a little while ago, right?
You have to do the research on the unclean hands doctrine, find the elements necessary to prove unclean hands as a cause of action, right?
And again, what was the name of the research that the gentleman from New York that was on the call last night, where he went to the library, what was the name of the book he researched, I think it would be the right way to say it?
Bender's. He went in Bender's.
Now, what is Bender's? Is that a law dictionary? Is that what type, is
like
that a publication?
Book?
Huh?
Bender's Forms book.
A what forms?
Forms book.
Okay, and every law library has them?
Yeah, everybody's got the forms book for their state.
So if I just go to the law librarian and say, where's the Bender's book, she'll know exactly what I'm talking about?
Yep, yeah,
okay.
Yep.
Okay. Thank you.
Yeah, we just don't know the power that we have, really. We've got the silver slippers on just like in the Wizard of Oz. We're Dorothy with the slippers. We just never knew or understood that we could get back at any time we wanted to Kansas. All we had to do is click our heels together 3 times. Right title and interest. That's trust.
Those shoes didn't come with instructions, did they?
No, they didn't.
Probably by
now,
design.
Is the Bender's book something we can find online by any chance, you think?
I don't think so. It's probably only going to be, at the law library or maybe look it up online get a copy. You could get a copy through West, say.
Okay. That sounds like that's really an essential publication that we need in order to proceed, huh?
Or else have a law library close by.
And as far as basic tools that we need that gentleman mentioned, is there any other kind of stuff that you think we need to be prepared for your upcoming workshop, and also to have in our arsenals of information. So as these things come along, is there anything else on the most basic level that you can suggest that we get our hands onto?
Well, a lot of that stuff, I'm trying to get the website up there functional so I can, add that stuff on there, and you can just go to the website.
As far as just basic working information for the workshop coming up, you mean?
Well, for the workshop, or, just general help under trust and some of the debtor credit stuff I'm going to put up there also. So.
All right, great. Thanks so much, Christian.
Looks like Harold's got a comment. Hey, Harold.
Okay, the name of the publisher is Matthew Bender.
Matthew Bender.
Matthew Bender, and it may be found in Matthew Bender's, Gould's, West. They basically all make forms for all the different states. But the one he went through was Matthew Bender.
Another question?
Yeah, I was having a hard time finding the Free Americans Yahoo group. I Googled it, and I'm not getting anything.
Yeah, if you type in groups, GROUPS, groups.yahoo.com / the Free Americans, plural. That's
Okay.
one word, the Free Americans, CANS.
All right.
It'll bring you right to the webpage. Groups, GROUPS, groups.yahoo.com / the Free Americans.
All right, thank you.
Yep. All right, next question. TX Sailor Boy, you've been unmuted. Go ahead with your question. Texas Sailor Boy.
Yes, sir. Can you hear me?
Yeah, you sound great. Go ahead.
Hey, Christian, I had a question.
Yeah, go ahead.
Great. You were talking about opening a bank account and, in the name of grantor. But if you went into the bank with trust papers already, I'm talking about a statutory trust, they shouldn't deny you signing the card as grantor in that scenario, would they?
You're correct, right? Mm-hmm.
So, don't you see the ability to walk the line between statutory trust and private trust?
Well, maybe I could, but I'm not sure everybody else could.
It's sort of like maybe you can come up with a good scenario of what it looks like when you put your commercial clothes on, or your commercial hat a certain way, and then your private hat another way, and just be able to tell the difference.
Yeah, here's what I see. It's not so much to set up a protective trust to protect my assets from the creditor of getting at my assets as debtor under debtor-creditor relationship. It's about coming at them with an offensive using the strength point from trust. I don't need a protective trust. Don't need one bit. All I need is trust when they're coming at us with trust, because the offer they're going to give me is what I'm going to turn into the trust. I don't need to have a protective trust. Don't even need to come in with a bank account under a statutory trust. I was just using that as an example. What would we do in case somebody didn't allow you to do something that you wanted to do because they're saying you got to be under debtor creditor? And I don't want to be under debtor creditor. I was trying to point out the fact that you really have the bigger power in taking them into a court of equity and forcing them into what they're supposed to be doing, rather than allowing them to breach and then come back in and correct the breach in a court of equity. That's what I was trying to point out. I really don't need a protective trust. I don't need a trust to protect any of my assets.
Oh, that's not what I wanted to use it for, but let me ask it this way. if you didn't want to go through the hassle of having to prove your case that you can do it the way we're talking about, and you just did it as a statutory trust, and you can absolutely do grantor that way, you're still the private trust grantor upstairs, which is really the grandpa over all the little statutory trusts that you might create. Is that wrong?
Statutory trust says that, we got to have all these trusts in writing. Even in the book, Gilbert's book, there it says that, it says in there at the beginning there that you can have an oral trust. An oral trust can be, unwritten. Doesn't have to be written at all. Now they come in with this statutory stuff that they're saying, okay, the statutes of frauds says that you got to have, under real estate, you got to have a written trust. Well, it wasn't that way to start out with. Now I realized that was a lot of problems to start out with when he started having oral trust, because now the trustee, with his self-interest, ended up keeping the property and didn't give it to the beneficiary. They kind of fixed that problem later on.
Well, I noticed in Arkansas,
he went to the
on
trust.
the deed of trust, they specify that you have to be an attorney, or you have to be, it can't just be anybody. So you're correct about them changing the rules as they go along in the statutory world.
Yeah, but that's my whole point. What gives you the right to change the rules and make all these unconscionable contracts just so that you can get some kind of monopoly over us as debtor creditors?
We let them do it because we don't know.
That's the problem. Because nobody's coming in the court and forcing them to do what they're supposed to be under equity and preventing them from breaching the trust.
Do you have confidence that the court will actually be a court?
You get it in the court of equity, and they got to.
Could you tell us why they have to? What are you going to use for enforcement?
The court of equity is going to assume that the trustee is guilty, and the only way he can prove his innocence is if he's made a record of a payment or a disbursement. That's equity, period. The court of equity doesn't care what your excuse is. Once you prove trust, and that guy's the trustee, the court of equity wants to know when you're going to make a payment. If you don't have a record of a payment, it wants to know when you're going to make a payment. If you're not going to make a payment, then we're going to breach of the trust, breach of court, and you're going to go to jail for contempt.
Didn't you say on the 26th?
Even the President of the United States is not exempt from that.
Well, I like it, but I thought I heard you say that on the 26th you went through great detail explaining this critical aspect, and I don't think you released that, have you? 26th of January?
No, the 126 was the one on the Tuesday, which I went from A to Z on the outline, how to really terminate the whole the whole straw man account.
Well, I wrote down what you said, how to get that call, and I couldn't connect with it last night, so I missed that program.
Yeah, I don't know. I haven't really given that up because I've been saving it to put it up on a website, and I just haven't had a chance to get it tweaked enough to get it up on there yet.
All right. Well, when can we expect it?
Yeah, very shortly, very shortly.
Well, thank you very much. I'll
the one guy spread real thin.
Christmas time, hopefully.
Hopefully before that.
Okay, well, thank you so much. You're doing a great job.
Well, I hope I'm making the point. I've been trying to concentrate on why, number one, that this UCC filing and the notice filing is so hard. And I've been trying to, really delve into that to figure out, how is it I can explain this a little bit differently, or what is the stumbling block that everybody seems to be stuck on? And I finally think I really hit it on the head, was really we're having problems identifying where do I form the trust from? Where does the trust begin?
Doesn't it begin with your signature, Christian?
Yeah, but then they still haven't been able to recognize that, and I was thinking, well, okay, it's they're confusing this notice filing with the UCC and the county as being the mechanism that forms the trust. No, it is not.
It's just the evidence, isn't it?
It's just the records that a trust has been formed, and it might have been formed 3 years prior. Because the mechanism that forms the trust is the present transfer of trust property. Which is always going to be past tense. Because by the time I get into filing a notice that I transferred property, it happened, say, 4 hours ago. Or it could have been 4 years ago. So when was the trust formed? Not when I recorded the notices. The trust was formed, say, when the present transfer of the trust property to the trustee took place. And that was, say, 4 years ago.
Nobody can dispute when it was formed. It's done by your conduct or...
Yeah, but they're looking for a manifested intent of the intent of the grantor, and that's where I have to have a record created. But I don't have to have a record created the moment that I transfer the property. I could wait. Maybe I got a problem. I need to prove a trust. And then 3 years later, I record the documents, which creates the records that I'm going to use to prove the trust. That was 3 years prior, say.
Well, sure. Anybody who has children knows that they're going to give the property to the children.
Right.
So there's a predetermined date in their mind what that is. They may not take any action until years after that date.
Mm-hmm. Then I don't think people were thinking about, well, how did you determine what to accept for value and return for value? Well, when they gave you the offer. And that's exactly what you need to look for, the offer, because you're going to turn the offer into the trust res property.
So in practical aspect, let's say I get a summons for a foreclosure sale or a summons for a hearing to come down and, say my piece. So I accept their offer for value and take it from there.
Well, I'm not accepting it for value. I may say I'm accepting their offer for debtor-creditor relationship, and I'm saying no thank you. I'm turning it into a trust, and I'm going to transfer it back to you as holder, and now you've got liability because you're holding the trust titles.
And you're saying this to the judge or the people that are suing you?
Well, the judge is going to be trustee, and the people that are suing me, I'm going to turn that case, that whole offer for debtor-creditor relationship, I'm going to turn it into trust property and use that as a special deposit to pay the bill, because the merging of the titles is the bill of exchange that is used to pay the debt. And it was
naturally
a trust deposit.
Right.
And then the filing of the UCC becomes the trust payment receipt.
So do we have to wait till the workshop before we get all the details?
Well, through all the calls that I've gone through since starting in November, most of the details are in all the calls.
Yeah, well, just try and boil all that down in about a few hours because, I don't know anybody has that much time to go back and listen to 40 hours. And, unless you have a lot of time to do that. Yeah. A lot of us have work where we're tied down to a job 8 hours a day, and then you got to run the regular household with a few hours left, and then by the time we get to you, man, we're really struggling, spending all night, and maybe somebody volunteer to edit out all these calls by subject. But here's all the minutes of April V. Here's all the minutes of court. Here's all the minutes of this and that.
Well, that'd be great.
Nice, wouldn't it?
Yeah, that would be awesome. But
I'll do it for $50,000.
Will you take a trust deposit for that?
If I know how to convert it.
Yeah, that's a good one too. We need to be taught how to convert it so we don't have to work for these slave masters.
Well, I don't have to really worry about that. I'm going to let the Treasury convert that for me.
Yeah, but until we get to that point, we're like kind of on a treadmill here.
Yeah, right. I know. And we
It's all about getting out of the rat race.
The system is designed under debtor-creditor.
It's all about social control, isn't it, Christian?
Yeah, really. Designed to keep you a slave.
Yep.
The best kind of slaves to have are those that don't know they're slaves.
Yeah, exactly. It all starts with the public school system, teaching you how to be a good employee.
Yeah, they don't want you to know or understand that you don't have to have cent here to do function in commerce, and commerce is under debtor-creditor. It's all fiction land. It's all Oz. And you don't have to have cent here in fiction land in Oz because it's all fiction.
And they hide it in plain view.
Just the records that demonstrates that you knew, even though you didn't really know. It's just what they can see. They can see a record, but they can't see the real live man. They can see a fiction piece of paper, a record, and that record is what they look at to say, oh, you had knowledge and understanding because your manifested intent. Here's your action to confirm that you knew, even though you didn't even know. You didn't know there was a trust being formed here. Just as when I gave you my pen and say I want my pen back, you didn't know that there was a trust being formed at that moment.
So if I can interject here, when you're talking about asking for the note back the way it was when you signed it, what are you using as your basis to ask that question? Because if you're getting these papers saying, hey, you didn't make your payment and you need to come to court so we can steal your house.
Well, first I got to prove the trust, and if I prove the trust, I'm proved that I'm grantor. And then if I'm the grantor, it was my intent and purpose that my note was under a special deposit. It should be kept non-commingled. And a special deposit, according to the special deposit, says that I get in kind back out.
But they're going to say, but you signed an agreement that said we could sell your note.
No, I didn't sign an agreement. You construed it.
Oh, it's right there in black and white. Did you sign that paper right there? It says right there, we can sell your note.
Yes, but that's not a debtor-creditor document. That's a trust document.
And how do you prove that?
In chambers.
Protective order. In-camera hearing.
I think it's fabulous. I can't wait to go to the law library now. Find one that's open on the weekend. That's all I had.
That's all?
Well, no, I don't want to take the whole show. There's a lot of people out there like to have this question answered.
Yeah, we got 5 more callers standing in line.
Okay.
Next one is...
Come on with another one then, Dave.
Okay, thanks.
Josh, you're unmuted.
Hello, my name is Josh. I've got an OID question, if you don't mind, Christian.
Yeah, go ahead.
Okay. In October of 2008, I received OID money back, and then in early 2009, they started communicating with me and letting me know that there was a federal tax due. So I've been trying to deal with this. I did the accepted for value and in that process, but they are still there for a while. They were just sending me letters that said, give us 45 days to review your account and we'll get back to you. And just so that it, wasn't, I didn't leave anything unsaid, I would conditionally accept those upon proof of claim that the accepted for value hadn't already settled, set off, settled, and closed the account. And then here recently, I got another letter that basically said, we still owe such and such amount, and penalties and interest had been stacked on top of that. And rather than do another conditional acceptance and perpetuate this situation. I'd like to do the honorable thing and help them close out the account, but I'm just wondering how I might do that through the expression of the trust, or maybe payment issued with a bond, the GSA forms maybe. I just really trying to get it closed out. I was wondering if you had an opinion.
What they're coming back and hitting you for the tax is based on the OID money?
Correct. You got
that OID money.
I'm sorry?
You received the OID money and cashed the check.
Correct.
And then they're saying they're taxing you on that.
Right. And the funny thing is they're actually stating that I owe the gross amount that was listed on the 1040, which I assume that I made the mistake of taking an exemption and paying the 30% tax, or I guess maybe not actually paying it, but at least deducting it from the gross amount. So the money that I received is actually 30% less than what they're telling me that I actually owe. They're actually telling me that I owe the gross amount that was listed. So,
right.
Interesting.
Well,
but on the
problems there, number one, you've set up your status as being trustee by filling out the 1040 form the way that you've done in the past, and that's really in conflict for the way that you're trying to tax back the funds.
Right.
That's in conflict with the SETI Key Trust also, because you've got yourself listed as beneficiary on that one. But then you got another problem too. You got that not just the master file being all out of whack, but you got a discretionary trust over which, per the discretion of the trustee of the U.S. bankruptcy, he's got the chance to withhold or whether or not grant your success.
Okay.
Those are the two main problems.
Okay. What course of action might you suggest on? I was going to mention this because I found it interesting on the notice of federal tax lien filing and your rights to a hearing under IRC 6320. It's interesting. On the front, it's all in one font, and then at the bottom of the page it says over, and then on the back side it's in a completely different font, and it goes on to say, we will also release the lien within 30 days after we accept a bond guaranteeing payment of the amount owed, or after we adjust your account based on the decision of your requested hearing. So I didn't know, if they're telling me something.
You're trying to offer the debtor-creditor relationship, which is nothing more than you're trying to create a bigger debt to pay a debt, and which doesn't really work. And under the discretion of the trustee, whether or not you have success at what you do, and some people do, some people don't. Most of them don't. So it comes back to I don't like the debtor-creditor stuff any longer. Don't do it. No, don't recommend it. I prefer the trust methods now, because the trust method is really the core of the operating how they're, and you need to close that down.
Yeah. Any suggestions on how I might go about that?
You talking about the dominoes, didn't you, Christian?
Yeah, it's a domino effect. You got to have all the dominoes in place, so when you push them down, they all go down. If one's out of place, then it stops right there.
Okay.
So it's my advice is, since November of last year till forward till now, all the tapes and stuff that we've been going over, the NTT process, which is New Trust Technology, and going over those tapes. Now I realize there's a lot of hours and stuff involved in that, but that information's all in there. I can't tell you just in a matter of 10 minutes, other than just give you the model or attend the workshop. Because I can't give you, other than just the model, in just a concentrated 15-minute scenario.
Okay.
It's really a three-step process. It's express and prove the trust, number one, and two, create, claim, move, and merge the titles. That's two, and three, collect on the disbursement. But that's in its simplest forms. Now, exactly how do I go about doing that? That's where the details are in the past recordings and the things we've talked about and the examples we've gone over and the questions that people come up with and, very valuable information on those past recordings.
Okay. And you said November?
Yeah, starting on 11/7, I think was the first one where I announced NTT.
NTT.
Yeah. NTT stands for New Trust Technology.
Okay.
11/7 or 11/5, I forget exactly the first date. But anyway, anything in November and forward, that's where the NTT is.
Okay. And would this be all spoken of in the Free American calls, or?
Well, I have several calls. The Free American call is just a Wednesday night call, but I've got a Monday, a Tuesday, a Wednesday, and a Saturday call. And what I'm trying to do is, get it all on the website because I used to say everybody, send me requests for the download links, and I would send them an email, but that took a lot of time.
Yeah.
What I'm trying to do is centralize it all in one location on the website, movingtitles.com. But keep checking there. That's the website, movingtitles.com.
Okay.
And
I'll start there. Thanks,
the download
Christian.
links will be up on that website very shortly.
All right. I appreciate it.
Hey, Christian, on these three steps, the express, prove trust, create, claim, move, merge, and then collect on the disbursement, does that necessarily have to go through a court of equity, or can it be done just by going directly through Treasury and the IRS?
Yeah, ultimately I want to just do it solely through Treasury. That way I don't even have to appear in court.
Right. That's the ultimate. Now, correcting your IMFs, does that have to happen before step one? Or kind of in step one?
Well, I kind of think that, to start off with, you're going to have a higher rate of success than, say, regular debtor or creditor, even if we don't correct the master file. But you're still subject to the discretion on the trustee, and he may withhold, may not give you a remedy.
Right.
Excuse me. But that's why you need to correct the master file, because once you correct that, then you pull the root out, and all the leaves of the trees are going to die.
Right. Have you discussed that process at all in any of the calls that you can remember? Of actually going back and correcting the record?
That's that Tuesday night call on 126 that Dave was talking about, which I really haven't released it yet because I was saving it to put up on the website, because that one I went through from A to Z and talked an hour on just in detail about the how to go about and claim that whole master strawman account terminated.
Yeah, I remember you talking about that. Once that goes away, then you everything is in trust, and then you create an LLC and you operate out of that LLC, but you can't sell anything because you get right back to debtor creditor again.
Yeah, because you're going to commingle. You're going to cross over the private side with the public side, and you just commingle the trust again, and therefore you just breach the trust yourself. Put yourself back under debtor creditor.
Yeah, you just contaminated it.
Yeah, you commingled it. You breached the trust yourself. Upon breach of the trust, you're going to put yourself back under debtor creditor.
Well, our next caller is from South Central Florida. Go ahead and state your name. You've been unmuted. Are you there? Can you hear us? Oh, he just muted himself back out again. I just unmuted you. South Central Florida. Do you have a question for Christian? All right. Apparently he doesn't want to talk. North Georgia's next. North Georgia, you've been unmuted. Go ahead.
Yeah, Fritz, Florida. Yeah, I was in a private bank, and they had one of their little brochures out, and they talked about the grantor, the settler, and all that. The trouble is, nobody knew about trusts, so all this stuff is right there in front of our face, but nobody takes the time, and nobody does what they're supposed to do. They don't do their homework, so to speak, and then they want to cry, and then they want everybody to hand them everything, and they want to be have all other, and then but they don't want to be a slave. You got that?
Yep. Got to come up with a knowledge and understanding yourself, yeah. Anybody else? Question?
Yeah, North Georgia had a question.
Hey, Christian, this is Susan out of Atlanta.
All right, go ahead.
You spoke about the TD 2506 in terminating the trust. Am I correct in that?
DIB hearing, yeah. The Treasury Directive, yeah.
Correct. In reviewing that, it talks about all kinds of things, but one of the things it talks about is the Computer Matching and Privacy Protection Act. Can you give us a little bit of an overview of what this is going to look like?
Well, all computers must match the master computer, which is the IRS master file. All other agencies must match that. And where are the records kept? In the computers.
Well, then it takes us out to a place called Privacilla. Is that correct? The proper terminology on that? Which is the Privacy in Government, which talks about the Computer Matching and Privacy Protection Act under 5 U.S.C. 552A, sequence O, and it talks about negotiated written agreements with other agencies, and so basically and it talks about the data integrity boards.
Right.
And then it talks about matching programs to Congress and the OMB.
Mm-hmm.
Is that basically all the files that are with us that we go in, and this is where they combine them all together?
Well, you see, that's supposed to be all tied in together. There's many computers with keeping track of all the different strawman accounts. But all those computers are supposed to be all linked to one master computer, which is the IRS. And all those computers, according to the U.S. Attorney's Manual, is supposed to comport to that IRS individual master file.
Yeah, because it talks about terminating or denying individual benefits and payments is what I was looking at.
Yeah, so under the Treasury Directive, you're going to correct the master file, and then through all those programs that you mentioned, and the U.S. Attorney's Manual under 6-4.010 basically says that all those agencies, all those computer agencies, all those computer files must match up to the IRS file. So I'm going to get it all in one fell swoop.
And to operate under the through this TD 2506 process, where does that actually start?
Where does
it actually start? The Department of the Treasury Data Integrity Board, because it talks a lot about the meetings and the councils and the inspector generals and et cetera, and the IRS Restructuring and Reform Act.
Yeah, well, look under the USAM, U.S. Attorney's Manual, 6-010. Look at that section. And it basically says that the individual master file, all other computer-generated records must match up with that. So if I correct the master file with the Treasury IRS Directive 25-06, calling the DIB hearing and ordering them to correct the files because they're inaccurate, then I correct all the computer files. Because all the other computers must be up to that IRS record.
Okay. All right, I'll do a little bit more research on that. Thank you very much.
Mm-hmm.
All right. Next caller from Michigan. Go ahead. You've been unmuted. Can you hear us?
Yes, I can hear you. How you gentlemen doing this evening? First-time caller, first-time listener. And I've heard you mention protective order twice. I'm just wondering exactly what that is and what situations would you be able to use that?
Well, you're going to use that to protect your CCI information, your confidential commercial information, which is really all your rights as a real man, a real woman. And that has to be used to protect the information from being waived in the public. Because there's a public side of the court and a private side of the court, and the private side of the court is where you want to take that CCI information, that trade secret information, and you want to put that in chambers, because that's where the private side of the court is.
Okay, so the protective order, you can use that with all types of court cases then?
Yeah, but it's a protective order so that you have a reason for going in chambers and discussing this confidential information.
Okay. And where would you basically get the verbiage or the information for the protective order?
Okay, that's what we were talking about earlier about the federal rules under 501, which basically says go to your local state rules and look up in your local state rules of evidence where you're, let's see, it's in Florida in particular, it's 501 comports down to 90.501 through 90.510. But in particular, the two is 90.506 and 90.507. And 90.506 is the privilege with respect to trade secrets. There's your CCI information, trade secrets. And 90.507 is the waiver of the privilege by voluntary disclosure. A lot of people don't know when they go into the public side of the court and they talk about these rights that they have. They got a straw man account trust. I've got a private administrative remedy, and they bring that in under the public side of the court, and they just waived it.
Okay.
So in order to get in chambers with your CCI information, your trade secret information, you got to put a protective order on it. Because really what you have is state secret information, which is against public policy.
Right.
And the only way to get it in chambers is to have a protective order on it so that they can grant an in-camera hearing. So where you can present your administrative remedy that was completed, your certificates from the notaries, and that's where all the real substantive rights are of the real man, right in chambers. And that's the only place where he has any rights. If it's in the public side of the court, he's under the debtor-creditor side of the court, and he's nothing more than the debtor. He's the trustee. He's the defendant.
Okay, so if a person was in a foreclosure or an eviction situation, this would be a remedy that they could use then.
Okay, mortgage foreclosure in the case of an eviction?
Yes.
Yeah, but there's a lot more to it than just, the fact that everything is a trust is too much truth in the court, so you can't have that in open court. That's got to be the trade secret information. And that's what has to be presented in chambers. So we're going to claim it's a trust, we're going to prove it's a trust, and we're going to bring that information, the proof of the trust, in chambers with a protective order on it. And we're going to come in with a special deposit that we've made as payment.
Okay. So a special deposit would be what exactly then?
A special deposit is a trust deposit. Special deposit is a trust deposit. They're both synonymous.
Okay.
Could that be considered trust res?
Yeah, that's trust res, right.
So that's an actual document that would bring in stating how much, whatever you paid, whatever you're paying.
It's more than just an actual document. It's a group of documents.
Okay.
But what you need to do is you need to get a hold of, like I was telling the other fellow, from 11 of last year, November of last year, and forward till now. Get a hold of all the downloads of the audios of all the previous shows and start reviewing all those shows. November, December, and January, and starting in February here.
Okay. All right, then. Thank you, brother, for your time.
Then I would suggest getting the Gilbert's Handbook on the Gilbert's Law Summaries. The one on trust by Edward C. Halbach, Jr., because that's the one we're kind of going by as an example of statutory trust.
That was Gilbert's, what again?
Okay, it's called Gilbert Law Summaries.
Law Summaries.
Yep, it's the one on trust. It says trust. And it's Edward C. Halbach, Jr., Halbach. Like $28 plus tax.
Okay, thank you very much.
If you want to know about trust, everything that's basic about trust is in there, what we're talking about. It'll tell you the 4 elements of the trust necessary to form a trust. It'll tell you the 4 methods of formation. It'll tell you all the basics on how they're operating under trust today. Because they're not operating under debt or credit. They're operating under trust. And when you don't express the trust, that allows them to construe the trust, and they're construing it to be under debt or creditor, and it's not under trust. So you need to know how to express the trust, prove the trust, and then collect on the disbursement of the trust.
When you say collect, you're not meaning that I would actually receive anything.
Yeah, I'm talking about collecting on the disbursement of all the funds that's available.
Okay.
That's what NTT, New Trust Technology, is all about, that we've been talking about since November.
Okay. So you're saying you could actually collect money from like different things you paid out to or something of that nature?
Yeah, collect on the disbursement, put on through special deposit, because you've expressed a trust, to claim the trust. And whatever's held in the trust then is dispersed.
Okay, I got a lot of studying to do there. Go back to November.
Yep.
Okay.
Mm-hmm.
All right. Christian, next caller, Northwest California. Go ahead. You've been unmuted. Northwest California, can you hear us?
Yeah, sorry, I was on mute.
That's all right.
All right, so what would be your first moves in a family court case? Would it be the NOI and the UC1, the claiming of the case along with the NOI, and as far as closing down the case?
My first move would be to know and understand that they were forming a trust and nobody knew or understood that.
Right, 7 years ago, let's say, and I'm the one that actually went to the court and then opened it up. And now I'm going to go in and I'm going to claim it. And then I'm going to give them the NOI. Is that how that works?
No, there again, for like the previous 2 before you, I'm kind of recommending the same thing to you also. Go back to the downloads on the shows and pick up where we've, on the basic stuff that we talked about previously.
Right.
We've gone over so many bulk of information that, by sounding what you're asking, that sounds like you're not exposed to what we've been talking about.
All right. Well, then also another question, just in general, NOI and SOI, that's all private, right? That's all.
No, not exactly private. It's used in court. An objection to is nothing more than an NOI.
Okay. What about the
notice.
SOI?
I object. That's a notice. But if you don't substantiate the objection with some kind of material fact why you object, then the objection is going to be overruled.
Okay. All right, and then what about as far as, I mean, if you could just, in general, go over how, like, what's the disbursement part, let's say, after you manage to, I don't know, I guess close down the family court case? Like, how does that disbursement work? Like, I know you were saying that you get all the funds back, the money from attorney fees and all that they've been screwing you on. It'd all be returned to principal, or
In the background that they've attached the bid bond, performance bond, and payment bonds. That's the big money there.
and so you would ask for that money back too in some kind of a letter, notice, or something.
Well,
demanded.
I'm going to claim the case to be a trust and prove that it is a trust, and that's going to be my trust res property, and it encompasses all the proceeds therefrom, and everything is attached to it, including the
So
bond.
what do I get record? What do I get record? Like, how do I? What if I have been paying, in cash, and like, how do I know what like the exact number that I should be asking them for it, or?
Well, I don't need to know the actual number. I'm just ordering it all back.
Okay.
Whatever the value is. Whatever the remainder is, whatever is after the case has been closed and settled, the remainder, I'm going to order it back. I get the disbursement.
All right.
But now, I don't know how successful we'll be at that because we're still under the discretion of a discretionary trust per the U.S. bankruptcy. They may withhold the disbursements and apply it to, say, some other debts that I have no control over because I haven't corrected the master file and they don't have standing as a grantor.
But the case would be closed down for good, and that would be a positive thing.
Yeah, I would say that you would have better luck closing the case down coming at it by trust instead of debtor creditor. But
okay,
so under the discretion of a discretionary trust.
So then would you or would you not want to play on both sides? Because I think I heard you saying something about giving them the colorable way out on the family court case by, trying to throw a negative averment at them or something like that.
Yeah, some way that they could recognize to bow out gracefully, yeah.
And that wouldn't make you look incompetent?
Clean hands that I've been talking about.
Okay. All right, thanks.
I mean, I don't want to discourage you from this. But it sounds like you have maybe, not enough knowledge in the trust way of interpreting what we're doing yet. And the only way you're going to get that is by listening, to some of the downloads and the stuff that we're doing, what we've gone over already.
I'm definitely not going to be jumping into anything. I'm just trying to get it all figured out because they got a 7-year-old girl seeing a psychiatrist and a counselor, and they're forcing my neighbor to do it. So I'm just trying to figure it out so I can help. But, yeah. Thanks.
All right. Appreciate it.
Hey, Rhonda, you out there?
I'm out here.
Do you have a comment for Christian or a question?
Yeah. What you was talking about earlier, Christian, about you're not free. There's a saying, there's none more hopelessly enslaved than those who falsely believe they're free.
Yeah.
You think you're free, you don't try to get out of it.
You don't know that you don't know.
Right. Now back to now we pretty much have found out that we're the trustee. We've made ourselves a trustee on the 1040 form. And that's in conflict with the set of key trust, the Social Security number,
right,
where we're the beneficiary. Okay, now, but we're the trustee. and say like with the IRS, and like the gentleman was talking earlier, and they send you the beneficiary because they're seeing themselves as the beneficiary, the estate.
Right.
They send the beneficiaries send a bill to the trustee, which is us. Now, earlier you were just talking about it, that the trustee has discretion whether or not to pay. So we're kind of co-trustees because the U.S. bankruptcy has the Secretary of the Treasury as a trustee. So would you say that we were co-trustees?
Yeah, co-trustees that are incompetent, yeah.
Incompetent co-trustees.
Yeah.
Because we're incompetent because we're in conflict with what's on the City Key Trust, or incompetent because we're not paying the bill when the beneficiary sends it to us?
Both.
Or both?
Both.
Okay.
We're doubly incompetent. But we've got the assets to pay the debt, and we don't pay the debt. We say, no, we don't want to pay the debt.
Okay. Would there be any until we get in unincompetent on the City Key Trust to where we claim that? Well, actually, we're kind of set up there the way we want to be, aren't we, as beneficiaries?
Yeah, it just depends which way you want to play it, because you really could play it both ways, either trustee or beneficiary. I think you got a win-win situation either way.
So it's really not, I mean, before we terminate the City Key Trust, we're in conflict on the City Key Trust and the IRS master file.
Correct.
So we really don't need to change both. We need to change one or the other.
Right, and I would change the master file first.
Change the master file to match the City Key file.
Mm-hmm.
What's on that? In the meantime, if the beneficiary does send us trust res as a trustee, a payment for a payment, is there no kind of protection? Like you said earlier, we're incompetent because we don't pay the bill. Would we have more protection by at least trying to pay the bill, by claiming it and moving it back to them, or to our co-trustee who is competent to go ahead and would we take discretion away from our co-trustee if we forwarded the property on to him to show that we was trying to be honorable and pay the beneficiary?
Yeah, because if you fulfill the purpose of the trust, then the trust is going to terminate. And if the purpose of the trust was to be a protective discretionary trust, if there's no reason for it to be a protective discretionary trust any longer, then that trust is going to terminate.
Now, are you talking about the termination on the big trust that is our ultimate goal? Or are you talking about a termination on the trust of the relationship that we have with a beneficiary now who has sent us a request for payment?
Well, again, it depends on how you want to play it. As trustee, you have liability because you're supposed to make a payment.
Right.
A beneficiary doesn't have liability because, they're supposed to receive the trust property.
Yeah, but what I'm saying is before we terminate the City Key Trust, before we terminate all that, and it's still sitting in what you would call a discretionary trust, that the trustee has discretion whether to pay or not to pay. We haven't taken care of that yet, but in the meantime, I'm a co-trustee over here. I'm kind of a half incompetent co-trustee because I'm in conflict. My two files are in conflict, but yet what I'm saying is if I'm still incompetent because my files are mixed and a beneficiary sends me a request for a payment and I forward that to my co-trustee, even though I haven't changed the master file, just the fact that I forwarded to him to terminate that trust, I guess, that payment, which is a trust in itself, is that going to take discretion away from him a little bit because I'm forwarding him the trust property?
Well,
even though I haven't changed the master file.
Yeah, I think if I made the acknowledgement of the debt and made the offer for the not the offer, made the order for the settlement, then that would automatically terminate the discretionary trust on this trust and automatically free up the funds for that that party that is functioning as trustee to actually pay them.
Right, but you wouldn't be able to make the orders until you had done your previous filing, got your homework done on the UCC 1s and the 3s to claim the trust, and or do you have to do that first?
Well, I've got myself set up as trustee already.
Okay.
So I probably don't have to prove that. I mean, it could be as simple as just putting in the acknowledgement of the debt and an order for settlement.
Okay, as a trustee.
Now, that would fulfill the purpose of the discretionary trust because, you know, the purpose of the discretionary trust was to protect the beneficiary from getting their assets so that the creditor couldn't seize their assets once they gave them the assets.
So I may not want to just necessarily put in an order to pay the bill that the beneficiary sent me this time. I may want to put in and send that bill or transfer that trust property along with an order to say, hey, take care of it all.
Yeah, you could tell them to take care of it all.
Okay. Let's see. I had something else, but I guess not. Must have been a lie. Forgot it.
Okay.
Okay, well, thank you.
That's all we have for questions tonight. If you got a question, folks, hit star 8 on your phone, and you'll pop up on my screen here. If not, Christian, looks like we can wrap up for the night unless you have any additional comments.
No, that's good. Maybe I can get onto the website and make sure that the downloads get up there. And we call it a night then.
Outstanding. Well, folks, thank you so much for calling in tonight. We had a great call, a lot of great questions. We will meet here again next week, same time, 8 p.m. Eastern. And just a reminder, it sounded like a lot of folks wanted to get access to these calls. If you sign up for the Free Americans Yahoo group, you'll get the link every week. I always check on the box for a special email to be sent out. And that address is groups.yahoo.com/group/the Free Americans. Thank you, everyone. Thank you, Christian.
Thanks, Matt.
You guys have a great evening.
All right.
And good night.